Okay, well, okay, we'll need a bit of help on that. Thank you very much. Yeah. Yes, Mr. Hill.
Well, I'm not sure where that leaves us quite actually on the ABK lending, because of course most of the charges
Was from the outset.
Was from the outset, and the charges have been incurred by December 2009, which is the end of the closeout.
Well,
so
we will see what Mr. Malik says about that. But as presently advised, it's difficult. Again, one needs to, in a sense, urge upon the appellants to identify what they're saying should have happened and when. And without that, those particulars, it's rather difficult to identify what losses are being covered.
Well, yes, and then one needs to chime that with what was said to the judge and what was explored with Mr. Khorfi in the evidence as well. And on that point,
anyway, you were going to come to what was said to the judge.
Exactly. Yes. I'm going to deal with that now. Look, we'll hand up the references, but can I just show you?
Well, it may be, sorry to interrupt, when we've heard what Mr. Malik has to say on this slightly revised approach, we might need a little bit more assistance from you, I don't know, but so we may call on you. Thank you, sorry.
Yes, so if I could just show the court the references that I think are common ground between us.
Thank you.
The first is in the skeletons. Leonard Friend skeleton at bundle B1, tab 54, page 837.
B1, yeah.
B1,
tab,
rather 154, tab 54, page 837.
Yeah, my B1 doesn't go to tab 54.
Oh, I'm so sorry. Must be B2 then.
I think B2 is what 54.
Yes, B2 tab 54.
Yeah, that's the skeleton argument by the first defendant.
Yes.
The quantum determination.
And it's paragraph 6.
Paragraph 6.
And as we see it, it's 6.14 and 6.15. So as it's put there, failure to repay ABK loans in October 2008 or by 2010, and the decision to take out CBK loan in 2010 was a failure to mitigate.
Right, well I read that. Now, how do we lock in Mr. Malik's new approach to that paragraph?
Well, what he's now saying, I think in this, of course, is their submission below to the judge. I think what he's presumably now saying is I think he must concede that some of the failure to repay ABK the start date must be late in October 2008, but we'll have to see.
We'll have to see.
Certainly
so
when it comes to conclusion, there was in fact, there was in fact a concession. I'll come to that in a minute. Paragraph 44 to 5, the point is made again. This, of course, is all Sarasin Alpen's skeleton. So the only people who dealt with this in any detail. So 44 and 45.
So 44.1 is gone. I'm not sure about 45.2.
Yes.
45.3 is still alive.
Yes, exactly. That's really it for the skeletons, although the learned friend's predecessor skeleton at paragraph 2, which is in the next tab, adopted as appropriate those submissions, whatever that means.
Thank you.
Then, tab 55, no, sorry, I just dealt with that. Then there's the closing submissions, which is in bundle F7, tab 128. Page 4576. the passages my learned friends identified, and we agree with them, from Mr. Brindle's submissions, start at 476 at the bottom under my lord,
Yeah.
and go through until the end of 4582.
Shall we have a quick read through that?
I would invite the court to. Yes.
So I've got to the top of 80.
It's to the bottom of 82 is the point.
Thank you.
Where it stops.
Yeah.
And there's one other passage which I'll come to, but just on those passages, my Lord will see the concession that's made at 4577 in the middle, where Mr. Brindle said we're not stopping the clock at October 2008, we are content to let the matter run till December 2009.
Yeah.
So at that point, they were suggesting that the point only ran from December 2009, which wipes out not only the Sarasin losses, but also lots of the ABK head sea ships. But that's not a concession that so far has been repeated this appeal. Well, sorry, it's been repeated in relation to the Sarasin losses, but the impact on ABK.
I've conceded that ABK.
Okay, so you're making the same concession.
I am, yeah.
You're to December 2009, which by definition overruns the Sarasin loan and at least the initial ABK loan.
Lots of the ABK lending, yes.
Hmm?
Yes, quite a lot of the ABK lending.
Yeah.
Yeah.
Okay.
The other point I'd make is that, of course, none of the defendants had explored or ever explored or grappled with exactly what the claimants could and should have done, and what would have been the result. And that certainly wasn't explored with the witness. The other point that arises is that you don't see the detailed points on the documents and LTV ratios and so on that my learned friend Mr. Malik has been developing before this court. And what you do see, this seems to be the high watermark of what they were relying on, is at the bottom of page 4580, which is the assertion about $70 million worth of shares, which, as I've said, is an assertion that we certainly don't accept, and it's not supported by the evidence, at least for any relevant period that we're concerned with. I don't know what the position may have been in terms of value pre-credit crunch, but for any relevant period we're concerned with, we certainly don't accept the 70 million figure, and we would accept a 30 million odd figure. So that's that reference. The other reference in the defendant submissions in closing is at page 4595. And it's the passage that starts with the words "the important points" and just goes over the page to the bottom of the second paragraph.
Yes.
And the last reference is to my closing submissions, which is tab 128, page 4744 to 4745, which again I'd invite the court to read, and there we do make the point about the costs that would be associated with any sale.
Right, give me the page references again.
4744 and 4745. But it's really the full text on both those pages.
So the top of 4745? Is that it?
Exactly, 474 and to the bottom of 475. So it's both those pages.
Yeah.
I'm grateful, my lord. So those are the references below, and as I say, one didn't get the sort of exploration that one would need for my learned friend to advance the submissions he does. That's all I was going to say about the appeal from Bank Sarasin. Could I just mention the appeal from the first defendant, who's not here? Obviously, they've abandoned their appeal. We have incurred costs on it. In due course, we do invite the court just to direct dismissal of that appeal with costs to be assessed.
Right. Thank you very much indeed.
My lord, if I could deal with the figures for ABK and see where we are. The judge was correct that before the loans were realised in October 2008, there was $60 million outstanding. And we know that there was $80 million of borrowing in the first place by the first claimant and the second claimant. But what happened was that prior to October 2008, well prior to that, $20 million was paid by the second defendant to AKB to reduce the capital sum because they wanted to reduce the capital sum. That's how you get $60 million, and that's clear from paragraph 133 of the judgment. As there were two main guarantees, which are cross guarantees between the two banks. On the one level, there was a $27.5 million guarantee in relation to the third claimant payable to AKB if it was called upon to pay a guarantee, back-to-back guarantee, with Bank Sarasin. And there was the reverse. There was another guarantee with Bank Sarasin for $21.66 million from the second defendant, which was debitable to the first claimant's account in favour of ABK. And I said that's 21.66. And what happened was, in December 2009, there was a mutual demand by the two banks. So what happened was that you had $21.66 million debited from C1's account at Bank Sarasin going to ABK to be credited to the account of C1 at ABK, and that you had $27 million coming the other way, debited to C3 at ABK and credited to her account at the second defendant. And that's, if you just to give the references, the judgment paragraph 49.3, 149, and you've got the KPMG report in bundles C9, tab 79 at pages 1304, 1305, and 311. But in addition, you've got the 39.1 haircut, which the judge applied in relation to the personal expenditure, which is in the judgment at paragraph 132 and 62. And you can see why the claimants didn't claim on the principle of the loans as regards C1 and C2. As regards the closeout, I accept the closeout was on two levels. You have the closeout in October 2010, when the notes were sold. And you have
2008?
Sorry, 2008, correct. And then you have another closeout when you have the cross guarantees being called in December 2009. And I've accepted that the failure to mitigate point is that point. That's December 2009. And I'm not raising that point in relation to Bank Sarasin. It's only ABK and CBK. And looking at the figures in relation to C1 and C2, we know those figures because we've got the settlement in September 2008 when we have 2010, sorry, when we have the earlier loans at ABK being paid off and a new loan being taken out. And so the figure for C2 was $24,889,990, and the figure for C1 was $12,684,242. And my submission is, it's quite clear that they were in a position, and they could have, and we say they should have, paid off that liability by realising assets at C2.
So what is the total liability of C1 and C2?
As at that date, the total liability was 24.8 million for C2, and as regards C1, it was 12.6 million.
So 40 million.
C3.
36, right? Is that right? What about C?
And then you've got the argument, which we're going to come to.
And what about C3?
Yeah, C3, the other side say, as at that date, it's 27.5, but that's a real issue between us, because I'm going to come to that when I deal with the certificate.
I'm sorry, I'm being very slow this morning.
Yeah.
In September 2002,
To September 2010.
C2's exposure was 24 million, correct?
In September 2010, C2's exposure was 24,889,000.
Right, that's strict to millions. C1's exposure was 12 million.
Correct, my lord.
And C3's exposure,
according to them,
was, according to them,
is 27.5 million.
Another 27. So the total in about 60 million.
Yeah. And as you know, the judge applied the 39.1 million haircut.
Yeah.
But does that figure of roughly 60 million, that's net of the haircut, is it?
It is.
Yeah.
That's before the haircut's applied.
No, I thought that was net of the haircut.
No, the haircut. The judge applied the haircut to that figure. That's
to
why.
the 60 million.
Yeah.
Oh, I see. Okay. Whew, right, you may be right. Okay.
Yes, but for purposes of mitigation,
Yeah.
and whether it was reasonable and so on, the figure is 60 million, subject to your point about the certificate.
It is subject to my point about the certificate. And the I agree with the point he's making. Well, can I just go back and then come to this point? Just going through things in order.
Yeah.
Grounds 3 and 4. One of the points that my learned friend was making. Well, that there's no real. He's trying to make out there's no real distinction between Article 94 and Article 65. But the fact is, there is a distinction. One is a much wider remedy, and the other is a narrow one, which has the word direct. And that Whiteley is clear in saying that Article 26, which is the equivalent provision in the UK, doesn't exclude claims for compensation on other provisions or bases. And what we say is that there's no finding against my client of any liability on any basis other than breach of the prohibition. On the failure to mitigate, the point we're making is that where there are matters entirely within the knowledge of the claimants, such as their means and ability to pay, it's incumbent upon them to be forthcoming about their means, particularly in circumstances where it's shown that even on their own case, is that the second claimant is extremely wealthy. And before the lending was made, C1 was representing, he had net assets of $163 million. It's also said, I'm just running through different points, it's also said that they did mitigate by taking out the CBK loan. And I say that's not mitigation. Mitigation would have been to pay off the ABK loan, not just to roll over that liability with another bank. It's said to your lordships that there was no complaint of non-disclosure, and that wasn't pursued. It was pursued. It's in the closing submissions. If I can take your lordships to bundle F7 at tab 128 at 4596.
Just repeat the page.
4596.
Thank you.
This is Mr. Brindle's submissions. We say in paragraph 29 that the claims contend that they maintained AKB borrowing, took out the CBK borrowing, as they could not afford to repay and see that and we heard a little bit more about that from Mr. Khorfi yesterday. We do not accept that the claimants could not repay the ABK borrowing. They have, despite requests, provided no disclosure to support the assertion, and further, in other contexts, positively contended they were extremely wealthy. We made repeated requests for disclosure, and we never got it. And that the system was that the other side served an expert report, Mr. Griffin, we served our expert evidence and replied, and we served a separate report dealing with what information is needed in order to deal with this case, and they never provided it. The certificate, this is what I really want to concentrate on, because it may be that your lordships haven't fully understood what my point is, and I'll explain that, because it is tied in with the non-disclosure, which the other side say that was never pursued, and we say clearly was pursued, and I'll give you other references to it. What's being said to this court, and what was said to Sir John Chadwick, is that this certificate proves that the sum certified was owing to ABK as at the 18th of September 2014. That's what the representation is to this court, and that was the representation to the Deputy Chief Justice. And we'll bear that in mind when I take you through the material. Sometimes a party, through no fault of his own, only has limited evidence of a fact, and the court in those circumstances may have to rely on secondary evidence. They say what the other side had to show was what is the actual figure for the loan liability of C through to ABK from December 2009 and September 2014, or indeed to the date of the quantum level. Well, what documents would you need in a normal world? Because I think it's being suggested maybe Kuwait is not a normal world. The first is you'd want documents from ABK as to the indebtedness, showing continuing indebtedness and the interest charged. Well, we didn't have a witness from ABK. We didn't have any documents from ABK. There are no notices of default. There are no demands. There's no claim for default interest. And merely because you do have a guarantee, which has an interest provision on default, doesn't tell you what has in fact been claimed or what is the true position. What you need to have is statements of account. Now, it said that, well, the second area of documents that you need, and perhaps a specific example of it, are the bank statements for the relevant account. It's accepted by my learned friend that whilst they did give disclosure for other accounts, this account they have not given a bank statement. And what sort of bank does not send out?
Sorry to interrupt. When you say this account, what do you mean? An account?
The numbered account.
The guarantee or the underlying account in respect of the original loan?
No, it's the guarantee, because the guarantee agreement has an account number. We saw that yesterday. It's that account number that we have got the bank statements, and we say that there must be bank statements for that account.
Is it usual to have bank statements under such an arrangement? It's an account in the sense that there are obligations.
Yes,
the account can be debited or credited according to how the parties make payments or to the contrary. But if you wouldn't have periodic statements in respect to such an account.
Yeah, because if you look at the guarantee itself, and we looked at this yesterday, it has the account number, and then Article 7 has the provision for where you get the statements of account, and you have a period to object to those statements of account, otherwise you're bound by the figure. And it's normal that when a bank debits you for a guarantee, it's going to debit you on an account. And we say it's obvious that there must be an account. Now, the reason we were given for the lack of availability for accounts was the one that was given by Mr. Hill at the original trial. And he said, well, we've been in dispute since December 2009, and for that reason, we can't provide you with the bank statements. And at that stage, and I showed your lordships to the reference yesterday, the judge just didn't believe it. He said that he did not find it credible at all that a bank, when there's default, stops sending you pieces of paper and statements. It's exactly the sort of situation where when you're in default, they don't stop sending you pieces of paper. They don't send you pieces of paper at all. And the third area of documentation, which I think is the greatest hole, is the pleadings from the ABK proceedings. We know that the proceedings existed and there was a dispute because Mr. Al-Khorfi accepted in evidence there was a dispute. And we need to see what was in fact being claimed in those proceedings, what's the set-off, and what's the principal amount. Now, let's look at bundle F7 and see where we are. Look at F7, tab 127, 4463. And then the interpreter at top of 4416, he said, then when he couldn't, this is about line 8 down on the page, my lords, and your excellency. Then, when he couldn't, him and his wife and his mother, they could not. Then our AKB tried the case against them, and up to now it is going on. And then at 4488, you'll see, Mr. Al-Khorfi, regarding this matter, there is a case now before the courts in Kuwait against ABK regarding the 27 million. That's the 27 million we're talking about here, because they have liquidated the collateral put by my wife before they have a conclusive answer from Sarasin Bank. Now that there is a court case in this regard, it would be absolutely critical to see what's there, what's being claimed, what's being set off. And we have repeatedly asked for the documents in relation to those proceedings. It's in the KPMG report, it was in that application we put before the court seeking it, explaining exactly why it was relevant. Just to give you the references, the KPMG report is C1 841536, the submissions are B2 tab 57 pages 915 and 120, and in evidence we put it if we look at 4492 to 4495, where we talk about those court proceedings. And at the trial, this is what Mr. Al-Khorfi said at 4495, my lords and your excellency, if we look at that. He's asked about these pleadings and the documents. He said, Mr. Brin, as far as I know, this is all we have, this one piece of paper in relation to all these proceedings in the Kuwaiti courts. And he says, I have given my lawyers the documents I have. Mr. Brin, there must have been lots more documents on both the first and the second stage you've described, must there not? If my lawyer has asked me about that, I would have given everything, and I have given them whatever I had, so you better refer to my lawyers. We've repeatedly asked for this, and now at the middle of the trial he said, well, I've given it to my lawyers, but we've never seen it. And it may well be that there's a very, very good reason why it hasn't been given. But I'll come to that possible reason in a second. When it's said, the other side rely on the judgment of paragraph 122 saying that the no case of selective disclosure was pursued. That's what the judge has said. He's wrong about that. It was pursued in the closing submission.
But it wasn't pursued in the nature of an application for what we used to call specific discovery.
Oh, that's all he means, that's right. But there's still a complaint.
Important,
No, not necessarily, my lord, because the question is what evidence is out there to prove their loss? It's for them to prove it. We've repeatedly said we want the pleadings in Kuwait and the documents, and they haven't provided it. And we complained at trial about selective disclosure. It's one thing to say, look, here are my documents. But if what you give is misleading, that is completely wrong. And what we're saying is this cries out for the court to conclude this is a case of selective disclosure.
And apologies, that was expressly abandoned by Mr. Brindle at trial, the case on selective disclosure. He was asked by the judge whether he was pursuing it. He said he was not pursuing it.
Well, let's have a look at the references now. So it's 4640. While I'm doing that, maybe my learned friend can give me the reference where an allegation of selective disclosure is abandoned. If we look about this, we're talking about the account statements in this part of the case, in the middle of the page on 4640, closing speech. What are we supposed to believe? That there never were any sent at all? It seems highly unlikely. What are we to assume? I would submit this is a glaring failure in the claimant's disclosure. And then at 4646, and at 4644, where he deals with it, he says, the certificate must be looked at in the context of the fact that we have much better and more reliable evidence, such as a statement which we say must have existed in this account, which would have shown and must show somehow or another where or other AKB actually did charge that interest. And so we should not need to be looking at one document where there is a lot of other documents I've seen. I make no bounds about it, withheld. That's a pretty clear allegation. And he repeats the allegation as he, over the next 2 pages. And as regards the reference to the pleadings, which Mr. Al-Khorfi said, you could have had it if you'd only asked. It's Mr. Brindle on page 4646. But the claimants have deliberately not given us the documents. Even Mr. Al-Khorfi yesterday was telling me existed. He said there were lots of them. Where are they? What he has done is to put in one, I submit, obscure document before the court. So it's quite clear that this allegation was being pursued. Now, it may be I'm just getting old and cynical, but I do smell a rat here. And if we look at bundle B2, tab 78.
The reference again?
Bundle B, let me just find the reference. Yes, bundle B2, tab 48, can't read my own writing, 765.
Yeah.
Paragraph 5, this is the statement my learned friend took you to, but he didn't take you to, he took you to paragraph 5 in full. In respect to the first and second claimant, the ABK lending was settled by way of a settlement agreement entered in September 2010. The only remaining facility with AKB is the third claimant's facility of 27.5 million, which is guaranteed by the first and second claimants. There have been foreclosures of properties by AKB in respect of that facility. Now, doesn't that make you wonder what the hell is going on and explain why we haven't been given the bank statements or any documents from those proceedings? They could have called the third claimant. So the fourth item of evidence which is missing that you would normally expect is to call the person who said they'd suffered the loss. They didn't call the third claimant to give evidence at the quantum trial. They didn't do that, so we couldn't cross-examine her as what was going on. And at the time of the liability trial, they weren't claiming interest post-December 2009, so there's nothing to ask her about. This cries out, why did the claimants avoid all of the 4 things I've outlined? And what did they do instead? They simply called the first claimant to give evidence and got him to produce this certificate, which he couldn't explain the calculation. He said he could get the calculation from the court, but it would take 3 years. Well, if you're told it's going to take 3 years to give the information to you, it's basically saying you're never going to get it. And one of the advantages of having a local judge here, he will be able to tell you whether it is credible. It takes 3 years for a party to get access to the court file in their own case. This is a deliberate blocking because they know that 27.5 million is not being claimed, and there's no, this interest figure they're claiming is not a genuine interest figure. And if you look at paragraph 5, when they say properties are being foreclosed against that property, if that's right, then the figure's not going to be 27.5 million on principle.
You, as you accepted an argument yesterday,
Yes, my lord.
you have to establish
Yes.
that the learned judge acceptance of the certificate was sufficient evidence
Yes, of course.
was so fundamentally flawed,
Yes, my lord.
variance with the evidence and so
Yes.
unjust,
It is.
that that finding of his should be set aside.
Exactly, my lord. I make no bones about it. If you look at the Hamlet statement, they've foreclosed on the facility they're referring to, and it can't be the figure of 27.5. Why are they not producing the obvious things, which is documents from the bank claiming that figure? Why aren't they producing the pleadings from the trading proceedings? And they haven't given us the pleadings because they've got cross claims. They've made it clear that they're claiming against the bank as well. If they've got a cross claim, they're probably saying you should never have made a demand. You're not entitled to make a demand. Hence, you shouldn't have debited at all, and so there's no liability at all. That's what it's all about. Because they're avoiding the underlying evidence, because either AKB is not charged a sums claim, or the sums claim have been paid, either principal claims, or they've got some set-off. We certainly know that on their evidence, C3 has a cross-claim because he referred to it in his evidence when he was cross-examined. And the other thing is, let's look at the other inherent position. What's happened is they're saying, well, look, C1 and C2 have to discharge all their liability with ABK in September 2010 because of all the pressure of the bank. And they were threatening to enforce security and all that sort of stuff. But instead we're being told 4 years later, nothing's happened against C3 for a lesser total amount, and that sum is still due and interest is being claimed and all that sort of stuff without showing you the documents. It just makes no sense at all, my lord. I fully accept there is a high burden on me, but I say the judge was wrong, and I can fully understand how he made the mistake.
Well, the learned friend is now challenging the authenticity of the certificate.
No, I'm not, because if a certificate is fake, it's that it has not been stamped and signed by the person who signed it. I'm not saying it's a forgery. Of course I'm not saying it's a forgery. What I'm saying is it's simply wrong. So there's a big difference between saying a document says something that's inaccurate and saying that a document is not authentic. And of course in some cases inaccurate.
Well, the judge's approach, as I understand it from the transcript, was that if he had seen an order of the High Court in London which said that Miss Rifai owed $6 million in interest to ABK, he'd be inclined to accept that as evidence that she did. And that's the basis of his finding. That the certificate is adequate evidence of the liability.
But look, that is a world apart from it. If you're a judge in England looking at an order, let's say of another judge in England, this is the context of proceedings where the claimants themselves are parties to these proceedings.
Not of the claimants, but of the court.
No, what I'm saying is the claimants are before the court. They have all the records, they have all the information, they've got the proceedings in Kuwait. They could have given us the documents that show
the judge says if he would be inclined to accept that as evidence without going out and looking at the material that had been put in front of the court.
Well, the material
that's
wasn't
his approach.
I understand that's his approach, but
It looks to me unimpeachable.
well, my respectful submission is impeachable when you look at all the evidence and the inherent probabilities as to what's actually going on, because it doesn't help you know to understand what the cross-claim is and whether that sum is being disputed and whether or not it's in fact they have to pay it. It may be on one level, if you're willing to go down the claimant's path this far and say, well, yes, there is that figure there, but that doesn't tell you what's on the other side of the coin, when they're saying you should never recall in the guarantee at all. And why is it the position that in 2010 there was so much pressure on the claimants, C1 and C2, that they had to pay ABK off, and they didn't have to pay C3 for another 4 years, and it's still ongoing? It just doesn't make any sense. The answer seems to be that that liability is either disputed, and it clearly is disputed, or that it's no longer there because they've had the foreclosures referred to in paragraph 5 of Ms. Hanlon's statement.
Yeah.
So my respectful submission is that what you're looking at is a sophisticated version of the three-card trick. What it is the court should have the bank statements, it should have the pleadings, and he keeps telling him, look, I've got this certificate, don't worry about those two things, just look at the certificate, just look at that. That's what's happened. What the judge should have looked at and said, well, what is out there, what should be out there, and not just focus on this bank statement. He should have the bank statements, that would have told you. He should have the pleadings and the Kuwait proceedings. And we were told when Mr. Al-Khorfi gave his evidence, well, no, if anyone had asked for it, you could have had the pleadings. That's F7, tab 127, 4495, 4501. He didn't call his wife to give evidence to support the claim. Instead of all of that, we have a certificate which C1 procured and cannot explain. So, in summary, in my respectful submission, the certificate is not good evidence. It doesn't reflect any cross-claim. It doesn't reflect any claim that the bank should never have called in the guarantee at all, which we know is a claim being pursued. And that where the judge went wrong was to focus on what C1 produced in the form of certificate without considering the absence of proper evidence, which must exist in the form of records from the bank, demands from the bank statements, without the pleadings or the records and the proceedings in Kuwait, which haven't been produced, or even evidence from the third claimant herself. So those are my respectful submissions in reply.
Thank you.
And I sincerely hope the Lordships will, and Your Excellency, will look at this certificate with let's say a careful eye, looking at the inherent circumstances, looking at what is in fact missing. Those are my respectful submissions.
Well, your submission is extremely helpful.
Thank you very much.
Does that bring our hearing to a close?
Yes. My Lord, I hope we didn't tax the tribunal as much as we did on the last occasion. I tried to put things succinctly as possible.
If I may respectfully say so, the speed with which this appeal has been presented and opposed has both been commendable in terms of dispatch, commendable in terms of economy, commendable in terms of realism, because some points have come, some points, well, a lot of points have gone, and of course he's extremely grateful for the realistic approach to the myriad of issues that were originally in play. So our grateful thanks to both counsel and indeed solicitors for presenting this appeal so well. Our thanks to our shorthand writer as well. And we will obviously consider our judgment, and we will send out a draft written judgment in due course. Thank you very much.